ACLU's argument is this was filed today, I think it said. Yeah, this was just filed today, earlier today. So let's see what they have to say about why they shouldn't have to, or why Johnny Depp should have to pay them $86,000. So here we go. Thank you for those saying the document number. I had found it a little bit ago. Okay, so here we got. This is their reply memorandum of law in further support of their motion. Preliminary statement. Mr. Depp does not dispute that New York law requires him, as the party that issued 3 document subpoenas, to reimburse reasonable production costs and expenses. Correct. The reasonable part of it is very important. Nor does Mr. Depp dispute that the ACL non-parties incurred this in fees. Nope. The bulk of that amount was incurred after Mr. Depp rejected several compromise proposals. This is not part of the law. Now faced with the monetary consequence of serving broad discovery requests on a non-party, Mr. Depp argues that the ACLU non-parties are not entitled to recover costs of attorney review necessary to identify documents responsive. That's because that's what the law says. That argument makes little sense in the context of modern electric discovery, and unsurprisingly is not supported by New York case law. Well, let's see then, because it kind of was supported by New York case law in the other memorandum, but that's what this is about, right? It's the argument. Mr. Depp is equally off the mark in arguing that the ACLU non-party's assertion of privilege and work product protection over a small number of documents waives the mandatory obligation to defray the costs of a non-party. Small number of documents? Bitch, you guys failed to provide 5,500 documents. New York case law does not support that proposition either, which would put non-parties to the Hobbesian choice of either waiving attorney-client privilege or being forced to bear costs that would otherwise be defrayed by the requesting party. And Mr. Depp puts forward no support for his position that the rates or the number of hours worked were excessive. None of Mr. Depp's arguments warrant denying or reducing the fees. Okay, so argument. Non-parties are entitled to recover attorney's fees under New York law. Mr. Depp does not dispute that the New York law provides for the reimbursement. Okay, good. But he goes on to argue that attorney review time and associated fees were not reasonably required to determine which documents were responsive to Mr. Depp's requests. No, that's not what he argued. He argued that the case law, does not allow for the recovery of those fees. That's what he argued. That's a different argument. Mr. Depp misstates New York law, where attorney's fees are directly related to preparing a document production in response to a subpoena ducis tecum. They must be reimbursed by the requested party. Multiple authorities in New York law, including recent authorities that Mr. Depp ignores, support that common sense reading. See Energy Transfer Equity LP versus Corvex Management LP. Awarding over $650,000 in non-party attorney's fees, including for multiple levels of document review. See also JHAC LLC versus Advance Entertainment, NRE Kagan, Walt Disney Peerboom, et cetera, et cetera. Guidelines for discovery of electronically stored information, Section 8B, guidance for commercial division cases, providing that non-parties should be reimbursed reasonable fees charged by outside counsel and e-discovery consultants. Although Mr. Depp maintains that attorney's fees for time spent on responsiveness and privilege review are not recoverable, the authorities he cites are non-binding, unpersuasive, and have been disapproved of by courts that have considered the issues more recently. So this is good argument. This is good argument here. In AYW Networks Inc. versus Teleport Communications Group, cited in the opposition's brief, the court declined to award attorney's fees arising out of a motion to quash subpoena, memorandum of law, and telephone conferences in person hearings related to discovery. Those are all costs that the ACLU excluded from its reimbursement request. Both Peters versus Peters and Finkelman versus Klaus acknowledged that attorney's fees, including review time, are recoverable, except they didn't award them in any of them. They said they may be recoverable. And as explained more recently in JHAC, to the extent Peters and Finkelman differentiate between review for production and review for privilege and relevancy, they do not provide a practicable rule because it is unclear whether time spent reviewing documents for production could be broken down into review for privilege and relevancy versus other purposes. Well, except that you guys did break it down. Like you broke it down in your invoice. Which one? That is certainly the case here with the ACLU non-parties in an effort to review efficiently had only one attorney look at each document. They called it sufficient. They called it efficient. had only one attorney look at each document for purposes of determining both responsiveness and privilege, and did not withhold documents based on relevance at all. I'm not sure about that one. Because reviewing for responsiveness was necessary to comply with the subpoenas and produce documents, it is a recoverable expense of production. Mr. Depp is equally misguided to suggest that the time for reviewing for privilege/work product and preparing a privilege log is not recoverable. Indeed, the subpoenas themselves demanded that for every claim of privilege, the ACLU non-parties specify in detail each and every ground on which such claim rests and identify generally what the document is and furnish a privilege log that includes a statement of the specific privilege claimed and the basis upon which such privilege is claimed as to each separate document on a portion withheld. Yes, that's because they need to know why. You don't get to just say it's privileged. Well, it's privileged. I don't have to give it to you. You shouldn't have any privilege at all in this case for any communications between Amber Heard and your counsel. She's not your client. Mr. Depp chose to ask for a document-by-document privilege log instead of a categorical privilege log, and he cannot make a demand for such time-intensive task and be surprised when it dramatically increased the fees, quoting Energy Transfer. It would not be reasonable to require a non-party to produce a privilege log at its expense or waive the privilege. So that's kind of an interesting quote. But again, we're talking about a little bit different stuff here that I'm sure they're going to get to. But the ACLU isn't fully a non-party the way they say they are. Nor should Mr. Depp be surprised by the volume of privileged communications when his subpoenas included a request for ACL communications about the underlying litigation itself. Yet they're a non-party. Yes, he's asking for information that they're not privileged on. Now, of course, their internal communications about their own litigation and trial prep is going to be there, but we're not talking about that. Mr. Depp fails to establish that the ACLU cannot recover the attorney's fees reasonably incurred. Requested production expenses are reasonable, so supported by detailed backup. I mean, your privilege log or your log of fees is whatever. So counsel's hourly rates are reasonable. Nothing but his own conclusory and self-serving assessment to dispute the reasonableness. A reasonable hourly rate is based on the customary fee charged for similar services by lawyers in the community with like experience and reputation. Do you have an affidavit? Mr. Depp does not cite anything in support of his bald assertion that counsel's rates are above market. Do you have an affidavit that supports the rates in the market? I mean, that would solve it. Moreover, the ACLU non-parties reduce the total cost by using a junior associate to perform the majority of the review, supervised by a senior associate without requesting reimbursement for any partner time at all. Mr. Depp raises no dispute at all with the reasonable rates billed by technical staff. I mentioned that these are probably those I would think are more likely to be included. Number of hours worked is reasonable. I guess counsel's costs are reasonable. Again, all they have to do is file an affidavit from another attorney who charges that amount for the same work. That would solve it. Conclusion for the foregoing reasons. Okay, so they didn't address one of the critical arguments of Johnny Depp's attorneys, which this is a mistake, in my opinion. One of the critical arguments in Johnny Depp's brief is that the ACLU is a closely related party to Amber Heard, but a party not in interest. So they're acting in conjunction with Amber Heard, which they literally were. I mean, that's the entirety of this claim, is that they were working with Amber Heard to effect the defamation. And they don't even address it in the reply. I think that's a mistake. Hopefully Johnny's team buries him with that specific thing. They don't even address or dispute the fact that they are a closely related party. And we have case law on point saying that closely related parties are not entitled to fee reimbursement.